Well, good afternoon and welcome to Wadham College Oxford for the live streamed webinar, Material Contribution to Damage, the Elusive Third Way. We're going to talk about what everyone, I think, reasonably regards as a somewhat difficult area of law, which is exactly how the concept of material contribution to damage works. I'm not going to say it's going to be completely clear in an hour's time, but it's possibly more realistically going to be at least as clear as it can be. That's our objective. And I'm confident on that because of the two speakers who join me today. First, Professor Sandy Steele, who sits on my immediate right, who's Professor of Law and Philosophy of Law at here at Oxford University at Wadham College. Despite his youthful appearance, Sandy has been a distinguished writer and scholar in tort law for a number of years. He was kind enough to provide me with a copy of his book, Proof of Causation in Tort Law, and he'll be pleased to know that I keep that book still in my study and consult it. That is somewhat mitigated by the fact that I still have a copy, my student copy of Tony Weir's case law book on tort, which I still occasionally consult. In addition to being a professor, Sandy's now running from here at Wadham College, what I think he's just started, the Law and Justice Research Hub, and we're acting in association with them. One of their stated aims is to engage legal professionals legal practitioners on current legal issues, as well as foundation questions that permeate the law. So that's a challenge certainly for me. Possibly less of a challenge for John de Bono, King's Counsel. I first knew John when he was a junior barrister in Liverpool. He's somewhat regressed since to become a King's Counsel in London, but he's undoubtedly the leader of in his field. As I know to my cost, he's a charming and persuasive advocate, and he also has a very considerable intellectual grasp on the law. So it's a pleasure to be here with him today, and this audience, I hope, will participate and take part in our discussion. In terms of people with the stream, there is an email address which you can see, or you will see, in the bottom left-hand corner of the PowerPoint slides, which I'm looking at now. Wasn't practical to stream in live comments. And I was told actually it's sometimes difficult with live comments because they can be a little bit disrespectful. So I don't know how they knew so much about the people who are streaming in. But anyway, we decided not to take that risk. But you can email into my laptop and we will hopefully deal with some of the questions as we go along. So I'm going to start off by just telling you a little bit about the title. The title is The Elusive Third Way, and John was commenting before he found it a rather elusive title. So it's one I've actually used before, and it goes back to the hearing in the House of Lords in the case of Barker and Chorus. And during the course of that hearing, Lord Hoffman said, we now have a binary system of causation in tort, by which he meant, of course, old-fashioned but-for causation, and that area or enclave, to quote Lord Roger, that became established known as the Fairchild exception. Unfortunately, he didn't say that in his speech at the end of the case. If he had done it, might have saved us a lot of the cases we've got to talk about now. So with that in mind, I did a case called Cookson and Novartis, appearing in front of Lady Justice Smith, and appearing for a defendant in front of Lady Justice Smith wasn't the easiest task an advocate could ever have. And in that particular case, the claimant was relying on material contribution to damage. And I quoted what Lord Hoffman said and said, well, the claimant can't prove but-for causation. It isn't within the Fairchild exception. So on the basis of the binary rule as to causation, the claimant must fail. I still have nightmares about the look she gave me then. Fair to say it's not the only nightmare I have about that case, but it's certainly the one that sticks in my mind. And she really wasn't very keen on the idea of there only being two facets, the binary facets to the causation in tort. And subsequently there's a case which I'm sure we'll discuss called Bailey and the Ministry of Defence, where she put right, or with the assistance of Lord Justice Waller, where she thought Lord Hoffman had gone wrong in Barker in terms of talking about a binary approach to causation. Now, the reason I call it elusive is because even at this stage, there's very real difficulty in defining precisely how it operates and precisely what the implications of it are. And that, I think, will form a part of our discussion this afternoon. So what I'd like to do, really, I'm going to hand over to Sandy now because he's the professor. And I'm going to go ask him to just start off telling us first where it all came from and where it went thereafter. So we start, I think, with Bonington Castings and Wardlaw, yes?
Well, I might, if I may, go back slightly before Bonington Castings, actually. So in an article that I wrote with David Ibbotson, we traced this language of material contribution to damage to the 19th century to some Scottish cases involving nuisance of rivers. So you have a number of polluters, each of whom is putting some effluent into the river, and it seems on the facts that none of them is necessary for there to be a nuisance. So, had one not polluted, there would still be sufficient contributions for there to be a nuisance. And each contribution isn't sufficient for there to be a nuisance. It's only together that they amount to a nuisance. And in these cases, they had said it's enough if you materially contribute. So if you put enough pollution in the river, you'll be said to be liable. And Bonington Castings and Wardlaw is, of course, another Scottish case. And here you get this concept of material contribution to damage being invoked in the context of the tort of negligence. So the essential ruling in Bonington Castings was that it was sufficient for the pursuer to show that the defender's breach materially contributed to the pneumoconiosis in that case. But I think the difficulty that we are wrestling with now and in the subsequent cases is that it wasn't really articulated in Bonington Castings whether that operated as an exception to the but-for test. So in saying that the breach contributed to the pneumoconiosis, so by exposing the pursuer to silica dust in Bonington Castings, was that contribution necessary for, was it a but-for cause of the pneumoconiosis or not? And it's really just fundamentally ambiguous whether it was a but-for cause, and there's no explicit finding in the case to that effect. A related ambiguity is that reading the case, it looks like the injury is being treated as an indivisible injury. So it looks like it's being treated as a case in which it's simply not possible as a matter of principle to say, even if we know all the facts, that some of the injury was due to the defendant's exposure and some of it was due to the non-tortious exposure in that case. But later, now we know that pneumoconiosis is a divisible injury and that we can say that to some extent each exposure makes the disease worse or more or less worse. That's been, I think, read back into the case, and sometimes it suggests that it really was a divisible injury. So we've got these two ambiguities at the heart of this core decision. Is it an exception to but-for? Did it really concern an indivisible injury or a divisible injury? And I think that ambiguity has infected the subsequent development of this line of cases.
So moving on, this is taking us into Hennigan now, yes? And to get to Hennigan, we skipped through quite a lot of case law, some of which we might skip back to. But this seems at the moment to be taken as the sort of most definitive statement as to where we're up to in terms of how many approaches there are. And it is 3. So we have first but-for, and then just skipping on to 3, we have Fairchild. But at number 2, here is material contribution to damage. But what we don't see in that definition is, I think, the points you've just raised, Sandy. We don't see whether it is an exception to but for, and we don't also see necessarily, and this is another feature of the case, is what material means in material contribution. But it would appear, looking at the reference to a divisible disease that Lord Dyson had in mind there, that it was a but-for case, that the material contribution had made a difference, but because the condition was divisible, you could actually make the defendant liable only for the amount they'd caused, basically.
Right.
And that would satisfy but-for causation, yes?
So on that reading, the second way really isn't a truly distinctive form of proving causation, because it's really just a special case of the first way. Because if we're saying it's a divisible injury, and but for your breach, some part of that injury would not have occurred, then we're essentially saying the but for test is satisfied. But I don't know if you want to come to this now, but there are other cases in which material contribution to damage has been applied, and we clearly have an indivisible injury, like Bailey in the Ministry of Defence.
Well, I think that's the next slide, yeah?
So Bailey concerned brain injury, which was an indivisible injury. Wasn't made more or less worse by the extent of the breach. Either the breach was a cause of the entire injury, or it was a cause of none of it. And it was held that but for causation, it wasn't possible to establish on the evidence, due to the limits of scientific understanding, that the breach was a but for cause of the brain injury in Bailey. But it was nonetheless thought to be possible to say that it materially contributed to the injury by contributing to the patient's weakness, and that overall weakness then produced the sequence of events which led to the brain injury. That was thought to be sufficient to amount to material contribution to the brain injury. So no but for causation, and it wasn't simply that the breach increased the risk of the damage, it was that by adding this weakness, it actually played a physical role in the occurrence of the injury. So we that seems almost directly in conflict, really, with what they say in Hennigan, and as I say, Bailey isn't really given treatment in Hennigan on this point, but we do have some authorities applying it to an indivisible injury. And then we have a third authority, Williams and Bermuda Hospitals, where Lord Toulson tells us that really this is an application of the but-for test, so seemingly agreeing with Hennigan, but in a twist. He thinks that the but-for test is satisfied in Bailey because but for the contribution to her weakness, and but for that overall weakness, she wouldn't have suffered the brain injury. But this involves, in practice, de facto, a modification of the but-for test, because we're not asking but for the breach, would the injury not have happened? We're asking but for this disease mechanism, the weakness or the sepsis in Williams, would the injury not have happened, and did you contribute to that disease mechanism? But we're not normally, that's not the normal question for the but-for test, is whether there was some mechanism to which you contributed, but for which the injury would not have occurred. So de facto, it's still operating as an exception to the but-for test, even if it's being redescribed as consistent with that test.
Yeah. So when we look at Hennigan, I've gone back to that. I'm going to ask you two questions about this, one of which you partially answered. But the first is, when you see that quote, it says 3 ways of establishing causation in disease cases. Now, are we going to draw a distinction between disease cases and clinical negligence cases in this context? because in the case of Thorley and Sandwell, which you may have seen, Mr. Justice Sewell, he dismissed the case on the facts, the breach of duty, but he considered he was bound by Hennigan to take the binary approach, but for or Fairchild. So first question is, was he right to make that obiter statement? Because that, I agree with you that when you look at those, although they say three, if you take the divisibility point, they are in reality two. Yeah. So was he right to say that the Bailey-type causation, which is modified but for in an indivisible injury, was he right to say that Hennigan had excluded that?
Well, with respect to Mr. Justice Hill, I think he probably wasn't right to say that, because on the one hand we have the authority of Bailey, which just simply isn't addressed in Hennigan. So we really have a conflict between these two Court of Appeal decisions. And then we have Williams and Bermuda Hospital Trusts, which, although it's describing this as consistent with but-for, the way it's applying the but-for test is effectively an exception to the but-for test. So against Hennigan, we can set Bailey, a decision at the same level of authority, but we can also set, I think, Williams and Bermuda Hospital Board, because it's effectively recognising an exception to but-for, albeit described as consistent with but-for, by modifying the way the but-for question is posed. So my reading of the authorities would be that in substance one can still have access to this third way, either by explicitly relying upon Bailey in the Ministry of Defence, which I don't think has been overruled, or by saying we can modify the but-for test so that we're asking, but for this causal mechanism which occurred, did you contribute to a causal mechanism which led to the disease, or to the injury rather, and but for that mechanism would the injury not have happened? And that effectively gets you the same result as material contribution to damage. It gets you an exception to the but-for test. So I think as the law stands, there is still an elusive third way.
And just coming in there, I agree with what you've just said from the coalface. I'm glad to hear there's some academic support for it and your respect for Mr. Justice Sewell. But at the coalface, reading his decision, I think many practitioners thought, oh, golly, we thought we'd just begun to understand what was going on here, and now we're back to square one. And I think a lot of people are confused at all levels by what we mean by an indivisible injury. Because are we talking about the final outcome, or are we talking about something like malaria, which is a trigger injury, where we don't know which mosquito causes it? That's one sense of indivisible. It's completely different from the sort of indivisible injury like in a hypoxic ischemic brain damage case like CNZ, where the damage is cumulative and progressive. But you can't, at the end of the day, divide up the outcome to say what it would have been with a few minutes less hypoxia. That's a different sense of indivisible, it seems to me.
I think the issue there is indivisible injury may not be the correct concept. It's more to do with indivisible event, isn't it? I mean, that was the criticism of Bailey, that actually the event was indivisible. He either would or wouldn't have had the, I think he aspirated his own bonnet causing brain damage. That either would or wouldn't have happened. But John, you do a lot of these cases, I know. And on both sides as well. So in terms of arguing for a claimant, would you be essentially saying that Bailey was still good law, that there is a modification for but-for in that sort of situation, quite how it's defined we can talk about in a moment, but there is some modification going on there, and that there is some third way in operation there?
Well, I think what's interesting is where the different strands of where we've come from. So you're someone who does clinical negligence and a lot of disease work. I'm someone who really only does clinical negligence these days. And then we have the academic strand as well. And it seems to me you've had a convergence of clinical negligence post-Bailey catching up with industrial disease cases. And then when I was talking to any academic lawyer around the time of Bailey and saying, wow, this is such a big change, they were looking a bit quizzically at me as if to say, you know, what's changed? This has been good law for a very long time. So I say that just by way of background, and I think it's interesting to think about that. In terms of practice in a clinical negligence case, material contribution makes a huge difference, because there are so many cases where you just could not prove on old but-for causation that the difference would have been the outcome would have been different. But you can prove that the breach of duty has made a contribution to the outcome. So in the old days, you would sit in a conference with medical experts and you'd say, if there hadn't been this failure of diagnosis, would the poor outcome probably have been avoided? And they'd sort of go, not sure. And you'd say, come on, don't sit on the fence. It's only balance of probabilities. What do you think? And now, when they're sitting on the fence, if you're for a claimant, then you might say, by the way, it's fine to sit on the fence. These are very difficult medical questions. But this breach of duty won't have helped, will it? And they say, oh, no, it certainly hasn't helped. They say, thank you very much. We've got material contribution. If you're for a defendant, then your problem is you've got to prove really that the outcome would have, or persuade the other side or the court that the outcome would have been the same in any event. So it's I don't know whether it's elusive or not. I'm thinking most of my cases now would rely on material contribution. That'd be my first choice.
But when we're talking about an indivisible event, let's say a stroke or something, something that either would or wouldn't have happened, if you can't prove but-for causation, how are you assessing materiality? Because normally when we talk about materiality in the law, we talk about something that makes a difference, don't we? A material misrepresentation or a material non-disclosure. But what is the essence of materiality if it's not something that makes a difference?
Well, I'm going to invoke a very legal concept of the cake. So if you have a cake, you have flour and eggs and sugar and butter or margarine, and you put it all in and mix it all together.
Yeah.
And once you've baked it for 40 minutes, you can't take those different bits out, but each of them are material to it. In the medical negligence context, often it's not difficult to say something has made a contribution to the final outcome. But there are cases, and stroke might be one, where you can't say that. Doctors talk about increase in risk, and this is a big complication for us because in the industrial disease jurisprudence, they're always talking about increase in risk, and I'm not sure that doctors are using it in quite the same way. So if you take a case like Wilshire was the House of Lords case where the claimant developed retrolental fibroplasia, a baby in a special care baby unit, having his oxygen monitored incorrectly in a vein rather than an artery. So they pumped the baby full of 20% more oxygen than they should have done. And the baby then develops blindness, retrolental fibroplasia, and the claim is dismissed by the House of Lords on the basis that the breach of duty gave a potential extra cause of the blindness, but there were 5 other potential causes, including prematurity. The claimant couldn't prove, or hadn't proved, because it may just have been a problem with the expert evidence, couldn't prove or hadn't proved that the excess oxygen had actually made a contribution. So it might just have done. But the evidence wasn't there. So moving on from that, I think a lot of these issues will depend on the expert evidence and whether something is just a possible cause or whether it has actually contributed. But if it has contributed, if not anticoagulating someone has made their blood has made it more sticky than it should have been, and that's contributed to an ischemic stroke, then maybe Mr. Justice Sewell was wrong on this, and maybe the claimant was wrong to make the concession that the stroke was an indivisible injury. Maybe the stroke in Thorley was the product of cumulative causes of which the coagulability of the blood was one. So I think you can argue it all sorts of different ways.
But to take your analogy with a cake, if you leave one of the ingredients out, you still get a cake.
Well, if you would have had a cake anyway, then there's no causation. But on Bake Off, they might disagree with you as to whether it would have been. The question is, would it have been the same cake? Would it have been properly called a cake or not?
The analogy I often use in illustrating this concept is of a bridge. So we can move from cakes to bridges if you don't mind. But if there's, so imagine there's a bridge which can take 20 tons in weight, and there are 3 vehicles on the bridge. So there's a 10-ton vehicle, another 10-ton vehicle, and a 2-ton vehicle. Now, if I'm not mistaken, the bridge will collapse because there's more than 20 tons on it. So the 10-ton weight is necessary. It's a but-for cause of the collapse of the bridge, and so is the other 10-ton weight. But if we think about that 2-ton weight, it's neither necessary nor sufficient for the collapse of the bridge. But it's there, and it is contributing to the collapse of the bridge, and so that seems to me what we're potentially looking for in these cases is something like the contribution that 2-ton makes to the collapse of the bridge, even though it's neither necessary nor sufficient.
But in that example, if your engineering experts told you that the bridge would have collapsed anyway, regardless of the 2-ton lorry, then whether the 2-ton lorry comes onto the bridge or not is irrelevant. The outcome would have been the same in any event. But
wouldn't we still say it materially contributes? So it's
not if the outcome. Well, sorry, from my view, not if the outcome would have been the same in any event. So if we go back to Bailey, what Mr. Justice Foskett was saying was, I don't know whether she would have choked and aspirated on her own vomit anyway. If she would have done, because of the pancreatitis, which was the non-negligent cause, then I would have found for the defendant, because even though there'd been a breach of duty, the outcome would have been the same in any event.
Well, I agree that's a relevant question, in that if it would have happened anyway, then you're no worse off as a result of the breach, and so normally you shouldn't be entitled to substantial compensatory damages. But I don't think that affects the conclusion that the breach still causally contributed to your injury. So it's still true that the breach in that type of situation would causally contribute. It's just that you haven't suffered any loss because you're not any worse off as a result of the breach in such a case. So like Jane Stapleton and Richard Wright, I would want to separate out this question of whether you've contributed to someone's damage from the question of whether you've suffered loss as a result of a breach. And in these cases, whether it would, even if it would have happened anyway, it's still conceptually possible to say that you've contributed. But if you're not any worse off, then you shouldn't recover. And then the question arises: well, what do we do when we don't know whether you would have been worse off, or it's impossible to prove? And I think Bailey is a rule. Bailey effectively does two things. Firstly, it allows you to show a contribution even conceptually when it would have happened anyway. So it enlarges the concept of causal contribution beyond the but-for test, but it also gives you this very generous proof rule, which allows you to succeed even if you can't prove that you were worse off in any way. But it sort of merges those things together.
But that doesn't get you anywhere if you haven't actually suffered any loss, because the outcome would have been the same in any event.
I think it does in other cases where, suppose in my bridge example, that all of the contributions are tortious, then and we're suing the 2-ton contributor. I think there's a reasonable argument there that the 2-ton contributor would be liable in damages and wouldn't be able to say it would have happened anyway, because in doing so they'd be relying upon the other people's wrongdoing. But in describing the liability of the defendant in such a case, I think we'd want to say you did causally contribute to the collapse of the bridge, and exceptionally we're holding you responsible because we're not allowing you to rely upon the wrongdoing of others to avoid liability to pay compensation.
This has moved on to the slide, actually, sorry to interrupt you, the one you in the Financial Conduct Authority, which I think is illustrative of this point, that where you have a number of tortious activities which all combine together to produce a result. You don't have to prove but for against each contributor, because otherwise they get away with it, wouldn't they?
And Mr. Justice Sewell, just to note, in the case you mentioned, does make this qualification in relation to material contribution. So there's a sense in which everyone is agreed that material contribution to damage operates as an exception to but-for test. What's disputed is the scope of that exception. So Mr. Justice Sewell is saying effectively this only applies in cases of multiple wrongdoers,
which is Fairchild,
but with the actual contribution beyond mere risk.
Yeah.
Whereas Bailey and Williams, I think, are formulating a broader rule which applies where you've got a tortious cause and a non-tortious one.
Yeah. So someone called Richard Wright's just emailed me, so it may be the same man.
It will be.
Yeah, I'm really pleased, but I was hoping to get a message on the email. It makes me feel like a television presenter now, reading out a message on an email. And he actually points out, I think correctly in my view, that Bonington, they viewed the injury as being indivisible, and he references the speech of Lord Keith, and that each contribution made the atmosphere worse, the injury more severe. I think that is a fair reading of Bonington. But the question, I think, that leads on to that. Of course, Bonington was a case at a time when people did not apply apportionment to what we would now call divisible injuries. And I think with hindsight, pneumoconiosis is accepted to be a divisible injury. And if that case was re-litigated today, the likelihood is that the defendants would seek to introduce evidence that the claimant would have had a degree of pneumoconiosis in any event, and the damages should reflect that. I'll see if I get another email disagreeing with that. But that leads us into apportionment, and this is from Mrs. Justice Smith in Allen and British Rail. And Allen and British Rail, which is a vibration white finger case, followed on from the Newcastle cases, the deafness cases, Mr. Justice Mustle. And it's interesting to recollect in my case, become aware of through studying other people's cases, that at the time those cases were decided, the claimants were arguing you shouldn't apportion damages. In other words, they were seeking to apply Bonington in a strict way on the reading of the case, saying that once we've proved a material contribution, something more than de minimis, we're entitled to all the money. And we're going to come to the CNZ case in a moment. That's a similar situation, isn't it? And Mr. Justice Mustle in Thompson, that's the Newcastle deafness cases, and then Mrs. Justice Smith, as she was in Allen British Rail, rejected that approach and said that if in the context of a divisible injury, you had a means by which you could apportion the damage so that you could reflect how much the defendant's material contribution, how much difference it made, you could do that, yes? And that, I think, is accepted in cases where the evidence permits as being a reasonable approach to divisible injuries, yes? And that goes back then to the Hennigan quote, that actually what Lord Dyson was saying in Hennigan was talking about divisibility. And if we're talking about divisibility and apportionment, all we're doing is applying but-for causation in a slightly different way, or a slightly more complicated way than simply saying it would or wouldn't have happened. So the question arises then as to when can you apportion? Quite a topical question, really. Topical in terms of cases ongoing at the moment, and also in terms of the general state of the law. Now, there's a whole range of possibilities as to how you can apportion damages. And the question really is how scientific or evidence-based the apportionment has to be. Yeah? Now, John, in the CNZ case, you persuaded Mr. Justice Ritchie of a large number of things, it has to be said. You seem to be persuaded of everything you said in the case, I'm sure that's purely fortuitous. But one of the things you persuaded him of was that because in that case, which was a cerebral palsy case involving hypoxic damage, because there wasn't a scientific way of apportioning damages as between the non-negligent delay and the negligent delay, he should effectively award damages in respect of the whole injury, right?
Yes, so it's important to note that this was his secondary ruling on causation.
Yes.
So I'm not saying I persuaded him, but luckily fortunately for the claimant, his primary ruling was that but for the negligent delay in delivery, the baby would have been exposed to less than 10 minutes of hypoxic ischemia, and less than 10 minutes of hypoxic ischemia is generally accepted to be non-damaging. So what he was considering was a different scenario where actually that the length of the delay was slightly less than he'd found, and where the total period of hypoxia was slightly longer. So he said, supposing that the baby was exposed to 18 minutes without oxygen, and that with reasonable treatment, she would still have been exposed to as much as 13 minutes without oxygen. In that scenario, on the medical evidence, she would have suffered a brain injury. But then on top of that, there was 5 minutes of negligently caused hypoxic ischemia, which made matters worse. So he was saying, we know that in any event in that scenario, the baby would have had an injury. But is the claimant entitled to damages for the whole of her injury, even though the negligence hasn't caused all of it? And he said that the legal principle is that if it's impossible to say what level of injury she would have had anyway, then yes, the claimant recovers 100%. And to be fair, I don't think I was persuading him of anything particularly new.
Sorry to accuse you of being persuasive.
Well, there was a case called John and Manchester where Mr. Justice Pickin in 2016 said the same thing, applying what I think was probably established legal principle, but we may hear from the experts that it wasn't. But in that case, the claimant had a small subarachnoid hemorrhage, so a bleed on the brain, which would have left him with permanent disability. He then goes to hospital and is negligently treated. There's a failure to correct raised intracranial pressure, so he suffers further damage. And that was negligently caused. So the defendant at trial says there should be a discount because you found us liable, but we all know we're not liable. We haven't caused all of it. But the judge said, well, I'll make a discount, but only if you can identify what the level of damage would have been in any event. And the defendant couldn't, so the claimant was awarded 100%.
So, Tan, is that an exception to but-for causation?
I'm going to give an academic answer, I'm afraid, that you might not like. But it's conceptually, it seems to me it's not, in that we're still asking the but-for question. We're still asking, to what extent did the breach make the person worse off? Did it change things for the worse? What we're uncertain about is the extent to which it made the person worse off. So it's really a question of proof as to, are we going to be make an exception to the normal rule that you have to prove how much loss you've suffered in a relatively fine-grained way or not. So I would understand this as a kind of exception to the proof rules that apply to but-for causation, or to the amount of injury you've suffered in a but-for sense. So it's conceptually we're still interested in but-for, how much damage would not have occurred for the breach, but at a level of proof, are we going to be generous or not?
And it's interesting that in hypoxic ischemic brain injury cases, it used to be thought, pre-Bailey, that unless you could prove that delivery should have been earlier so that the baby would have been uninjured, you couldn't bring a case. There's been a significant increase in the number of cerebral palsy cases which have been litigated because of the availability of material contribution and Bailey.
But if you're accepting the onus of proof is on the claimant, and you know the defendant hasn't caused all the damage, yes, and so the claimant can't prove what portion was caused, you are modifying the test of causation to an extent. It's there's a but-for element in it because the injuries has a but-for element in it, but you're still modifying it to an extent, aren't you?
Well, hasn't it always been like that? I mean, wasn't that the same with Bonington? And it's not new to medical cases that you might not be able to prove how much of a difference it made. If you call that a modification to but-for, well, maybe.
Well, the question relates also to what is the threshold for apportionment? How good does the evidence have to be to apportion? And I'm sure it wasn't your fault, John, but Mr. Justice Ritchie quoted this from Lord Justice Irwin in the case, I think it's called Konjak, which is a stress case. And in that, a lot of the stress cases, psychiatric injury from stress, have an element of vulnerability, of likelihood of psychiatric injury in any event. And this was raised in the Hatton and Sutherland as to how you apportion. And Lord Justice Irwin, in that case, is taking quite a strict approach. He's really sort of saying that the medical evidence has to come down to a fairly accurate assessment of what the claimant would have been like absent the breach of duty, and then compare it with the claimant's current condition. And that, I think that influenced Mr. Justice Rich's thinking in the CNZ case. Now, when you look at the evidence in the CNZ case, there was what was called an aliquot theory of how you apportion injury through periods of delay, which was devised by, I think it's accepted, some very authoritative experts,
yes.
Lewis Rosenblum
Yep.
and Janet Rennie. Now, when you go back to Allen and British Rail, the apportionment there, and in fact we see it in the quote, if I can take you back to that, is that Mrs. Justice Smith, they're making evidence to Mr. Mitchell. Now, in White Finger case, so that was Bob Mitchell, an engineer, and what he used to do was he just used to prepare projections of how much vibration exposure people would have had with or without breach of duty, and then said, well, then applied in a very broad way to the medical evidence so that you could say, well, actually, this has caused a progression in a particular individual's case. But it wasn't in any way specific to that individual other than a general prediction from statistics.
So it's interesting because in the course of argument in CNZ, Mr. Justice Ritchie talked about that and said, I can see why in a vibration white finger case or a deafness case, where the overall level of damages is relatively modest, it might be disproportionate to adopt anything other than a broad brush. He was interested in CNZ in saying, well, could we divide up the outcome based on the fact that, so Dr. Rosenblum for the defendant was saying most children who've had 10 to 15 minutes of acute profound hypoxia, no blood, no oxygenated blood, will have the following features. And then once you get to 15 to 20 minutes, they tend to have a more severe disability, which can be categorized in this way. But so he was interested, the judge was interested in that, but was persuaded in the end that, or decided in the end, not necessarily persuaded, that the outcome could be very, very different in lots of different cases. So you'll know, but routinely in cerebral palsy cases where liability is admitted, you can't just jump from the approximate length of the hypoxic ischemic insult to say, that's a £5 million case, that's an £8 million case. You have 10 different experts in physiotherapy, speech and language therapy, accommodation, all the rest of it, to address the particular needs in each case. So sure, you could do a rough and ready discount, but it would be rough and ready if we're talking about, millions of pounds different. And what do you think about that, Charles, from your experience of doing these sort of big value brain injury cases?
Well, you do lots of rough and ready calculations. I mean, what about life expectation? That's a rough and ready calculation.
Well, life expectation is I'm really glad you've mentioned that, because you're right that in a CP case you would end up with the neurologist giving their opinion on life expectancy, but they will do so on the basis of very good medical literature, which is based on this California database where children and adults have been followed up for decades to say, depending on your level of injury and disability and function, what is your life expectancy likely to be? And the judge discussed that with Dr. Rosenblum, and Dr. Rosenblum agreed that it would be good in these cases where the NHS has had years and years of experience, if records had been kept of, how long was the insult in a particular case, and what was the outcome. So that's an example, going back to Lord Justice Irwin in Contract, of how the evidence could be there, but it isn't there yet. So a bit like your example of pneumoconiosis, now being understood to be divisible, it wasn't at the time. So it may well be that CNZ heard in 10 years or 20 years' time, there might have been a division, because the injury is not divisible, it is not indivisible, it's just not divisible yet. Yeah. Because we don't have enough information. Sandy, what do you think about that?
I think that there's a useful distinction which others have made between what we might call theoretical indivisibility and practical or evidential indivisibility. So theoretical indivisibility exists even when all the facts are known. So suppose we've got all the evidence we could possibly want, it's still impossible to say that of any particular breach that it was a cause of some particular part of the injury. So it might be like a leg break, is something like this, where even if we know all the facts, we can't say that a particular breach was a cause of a particular part of the broken leg. It just doesn't make sense in some way. But in other cases, it's just practically or evidentially indivisible, and I think CNZ is potentially an example like this, where in principle we would be able to say the breach caused this part of the person's functional disability or functional outcomes, but we simply don't know.
So Mr. Justice Ritchie said in CNZ, this is a divisible injury because it has been, there's a progression, and he describes the progression across the brain caused by the lack of oxygen. But he said the functional outcome is indivisible. And so maybe that's getting at that distinction, because the sort of theoretically indivisible cases will be indivisible sort of from the start. They're just indivisible whichever way you look at them, aren't they?
Yep.
Another message from Richard Wright. I mean, he's proving a very active member on the email. I'd invite more comments on the email, by the way. But he's agreeing with you, Sandy, that a tortfeasor should not be liable for the harm that would have occurred anyway due to non-tortious contributions. But we should not confuse the divisible versus individual nature of the injury with the possibility of apportioning the damages, as is done in much of the conversation in this area. I think it's a reference to us. So we've been confusing those two things.
Well, I don't really want to answer that question. I wanted to ask you, Charles, about asbestos cases and this question of rough and ready apportionment. I mean, isn't it true in the asbestos cases when you're looking at apportionment in terms of contribution to risk that an extremely rough and ready approach is applied in that context?
Yeah, I want to come on to this really. You see, I think the thing about apportionment is this: you can always apportion, right? Because you're giving damages, aren't you? And we apportion every day of the week. Now, it just seems people get a little bit precious about it in certain cases where it's going to knock the damages down, right? So in Barker, it was the House of Lords, said we will apportion damages. And I think I picked out that quote from Lord Hoffman. And it's an interesting story, really, because in Fairchild he said to apportion damages on the basis of causation was heresy. Yeah? But he was a remarkable convert because, 5 years later, he decided you could do it, really. And some of that was to do with, I think it's quite clear that a lot of the judges involved in Fairchild ultimately put it under the good idea at the time logo. And there was some rowing back. But they did actually, in Barker, say what Hoffman says there, that we've created this exceptional rule, so we're relieving the claimant of the obligation to prove but-for causation, but we're recognising that that's a big advantage to the claimant. I'm putting it simply, but I think I've got it right. But so we're going to smooth that out, and we're going to apportion. And the result came as a surprise to some people. Lord Roger dissented, and he said, well, he quoted a Scottish case, which he always did, of course, and in that, talking about, well, you can't divide up a sheep. Well, that begs the question whether the sheep's dead or alive. But his point wasn't opposite anyway, which is that you can always divide up money, and we do it every day. Because the Law Reform Contributory Negligence Acts, we just divide up on what is effectively an arbitrary approach in relation to the severity of the injury, or can be. And also in cases involving disputed liability, I'm sure, John, you do this all the time. You go in front of judges and say the claimant will take 60% or 70% or whatever. So we're apportioning damages. So why do we have to get so sort of precious, I'm going to use that word, about scientific proof, when in fact it's well within the exercise of our legal system to achieve these apportionments? And there's a good reason for doing so, because it means you get to a solution which, to some people's eyes anyway, would appear fair. So I think that's an answer to your question.
Well, it depends how you're going to carry out the exercise. Because you could say in a case like CNZ, we're not going to bother having the experts give their evidence orally, because we can just make a rough and ready assessment on the basis of what's written on paper. We can, in fact, get ChatGPT. There are some judges who are quite keen on this, aren't they? Get rid of the lawyers and the experts altogether. Just type it all into a blockchain and get your answer. But for the individual claimant, I don't think it's right. And I think the individual claimant, particularly in a brain injury case, who has very profound and severe needs, which is why these claims are on a full liability basis worth 10 million to 20 million pounds, it's important for that claimant not to have an unfair discount of 25% or some other arbitrary figure unless there's a proper basis for doing so. Now, it matters much less if the stakes are lower and you've got a lower value 5-figure claim. But when you're in 7 figures, those sorts of discounts make a big difference, and so shouldn't be done unless it's on a scientific basis. That would be my view.
Yeah, but it's a lot of money to the defendant as well.
Who is the tortfeasor, who's been found to have caused a brain injury. I mean, I say this as someone who often acts for defendants. I'm not some campaigning claimant lawyer. But the NHS itself is very clear that, when it's found to have been in breach of duty, or when it considers it's in breach of duty, it wants to pay compensation and do things right. So, I don't know. I'm not trying to get political about it, but just on principle, with a claim of a high enough value and of enough importance, just doing an arbitrary discount and saying let's knock off 25% is not good enough. And I just wonder whether you think that maybe, Charles, some of the asbestosis discounts and sort of rough and ready apportionments were really pragmatic in the context of there being hundreds and hundreds of claims, and by the court adopting this approach, it actually opened the door to those claims all being settled and not needing to trouble the court. So, in other words, the judges were dealing with the reality of a practical situation. Do you think that was a factor?
I agree it was, and if you look at the Holtby discounts, they were percentage discounts, whereas if you take the Lord Justice Irwin approach, they were not specific to the difference in a claimant. So if you were responsible for 30% of the exposure, you paid 30% of the damages, but it may have made a bigger or lesser difference if you'd analyse it more in medical evidence. But I'm still not buying the idea, because it's expensive, we have to throw the defendant's interests out of the window. I'm still not buying that. There's a way of doing it, and why is it unfair? What about the audience? They're all young people here. They're probably only just born when Fairchild was being litigated. Is anyone going to express a view as to whether they're horrified by the idea of damages being apportioned simply on a risk basis or a causation basis? They all look a little bit intimidated.
Could I make a point about
what you want, Sally?
I mean, I suppose your approach does gain some support by a kind of analogy to Bailey. So in Bailey, the injury seems to be theoretically indivisible, in the sense that, even if we had all of the evidence, it wouldn't be possible to say that the breach was a cause of some part of it. It's either a cause of the whole thing or nothing at all. So in that sense, it's an indivisible injury, and it's theoretically indivisible. But you might say, in a case where it's practically indivisible, it's just scientifically impossible to come up with any kind of reasonable assessment of the proportion for which you are but for cause, that's just analogous to a case of theoretical indivisibility. And if we're going to give you everything in that sort of case, we should also give you everything in the...
Because by logic, if you're going to make a discount in the CNZ, then the judge in Bailey might have said, I'm going to give you 50% of the damages.
Right, because that would be equally arbitrary, sort of rough and ready. There'd be no...
Charles would approve of that.
I think it's interesting you say it's unscientific to apportion, but it's unscientific to give someone damages for a full loss when you know that the defendant didn't cause the full loss. I mean, it's just as unscientific, isn't it? You know it's not true.
But there's a quote from Lord Phillips and Sienkiewicz, who says the broad test of balance of probabilities so this is in causation generally, means that in some cases the defendant will be held liable for damage which he didn't in fact cause.
Yeah, but they will also get away with damage they have caused. Yeah.
Exactly. So it will all even itself out. But if you're saying, well, it's unfair to defendants, they shouldn't have to. There should just be some sort of discount. Well, maybe the answer to that comes in the fact that there are settlements. Most of these cases don't go to trial. And one of the reasons they don't is because of the inherent uncertainty of the outcome, because it does depend on how the evidence comes out, and you won't get the same outcome in front of 10 different judges. But there, I suppose the parties have some control themselves over what the outcome is, and they're prepared to take a pragmatic view. It does raise another question, though, which is it's much easier to settle a case and reach a compromise if you all know what ground you're standing on. And that's why these sorts of discussions are quite important, because if the law is very unclear, it makes it much harder to predict the outcome of a case, which makes it less likely that you will settle a case. I don't know. That's my perspective.
Yeah. Okay. Well, we're coming to the end now. So I don't know. Is anyone going to ask a question? Make a comment? Well done. There's a microphone, actually. Yeah.
Thank you. No idea whether this is working, but I did have one question. I feel like it's probably a very law degree essay type of question, but do each of you individually think that material contribution is actually a good idea in terms of like wider impact on the law? Because I'm hearing varying degrees of balancing claimant and defendant interests and so forth, and I was just wondering, is it a good idea?
I think it's a good idea because there were a lot of cases, clinical negligence cases, where you had breach of duty, so substandard treatment, and because you couldn't prove how much of a difference it made, you couldn't get the case off the ground, and that seems to me unfair.
A qualified yes. It's a yes because I think it is possible to be a cause of something, even although it would have happened anyway. And I think the idea of material contribution gives the law language to express that. And you see that in other contexts. It's not just a medical negligence principle. It applies across the law that you can causally contribute to something even if it would have happened anyway. So to that extent, that conceptually recognising, and it could be important in lots of legal contexts, that someone can be responsible for something that would have happened anyway, I think is important and a good thing. But I think there's some serious problems in the existing law in terms of the clarity of what is meant by material contribution to damage. And it's this constant temptation to reformulate it as a principle which is consistent with the but-for test, I think only gives rise to confusion.
I sort of agree with Sandy. I think it is a good idea, to quote your expression, but it's not a good idea the way it's working now. I think it's a bit out of control, and there are a lot of anomalies in it, really, in the way it's operating. And well, it keeps us busy, so why are we complaining about it? But thank you for your question. Anyone else? I think we're out of time, really. Well, that's 1 minute to go. 1 minute to go. Well, I'm going to thank Sandy for his hospitality, John for coming, and showing us his persuasive skills. And I'd like to thank you for coming as well. And I'd like the people on stream, particularly Richard Wright, who was a very active participant. And I think we'll pull stumps there, if that's okay. Thanks. Thank you.